You're listening to the Law Frog Radio Show with David McDivitt and Ross Ford on Kilo 94.3 FM. Presented by McDivitt Law Firm.
Let's see. Let's go on one that's kind of topical here. The one about the guy. I was trying to explain it earlier when we were plugging the segment. It's almost like a Ponzi scheme with auto parts. The story's been in the news. This guy is Justin. He's a victim of a major theft. Local mechanic was taking cars to do performance work and then stole like parts and stuff. Motors, actually whole motors were taken and then resold. And then he'd buy their parts and fix stuff. It was, like I said, just trying to keep afloat that way. And the whole thing kind of collapsed, and then they arrested the guy. So all in all, he lost $16,000, not including $7,000 I spent afterwards to put a motor back in my car and get it driving as. The question, should I file a small claims lawsuit against this guy? Is it even worth it? At this point, what should I do? Ultimately, I want my money back. To me, it just doesn't seem fair that he can do something like this and essentially get away with it. His bail is posted at $10,000. And personally, it makes no difference to me if he serves time. Justice to me looks like getting my money back and him having to pay for however long it takes. Any advice would be greatly appreciated. And then you got links to some of the stories, but some I'm sure something you heard of in the news.
It's nuts. Yeah, and so the guy's not in Colorado anymore. They caught him out of state, didn't they?
Yeah, he went running.
Yeah.
So we can't say guilty or not, but that's not a very good sign.
It's a bad look.
It's a bad look. You know, exactly right. It's a bad look, bro.
It's a bad look for this guy, and he's apparently allegedly been doing this to a number of people. I mean, let's just go to his specific question, which is, can you file a small claim? Can you file a claim in small claims court? I mean, he could. I think he's giving up something, though, because it sounds like this was a pretty significant theft of a dollar value that's greater than what you would have adjudicated in small claims court.
Right. So that's felonious. $6,000, $7,000 for a new motor. So he's talking, a good $22,000, $23,000.
It could be, yeah. And so in small claims court, it's usually capped at $7,500. Wow. So if you go in and the actual true damage amount is greater than that, you basically waive anything above the $7,500. So I'm not sure that's the right step for this guy to take. I mean, he can file a lawsuit without hiring a lawyer, not in small claims court. You don't have to have a lawyer to file a lawsuit, for $1 million.
But it seems like, okay, from my outside perspective of the law, it seems like, so let's say Justin does that, files it. He's got a smoking case against this guy. It's a quick trial. They find him guilty. Punitive damage, $25,000, level the gavel, ... He's not going to see that money. That guy can file for bankruptcy. Right, and then wash that all away. There's no way to really get that money back from the guy. You're not like IRS can put a lien on your house or garnish your wages.
No, you can still get some of that stuff. What you have to do is you have to reduce it, any kind of thing reduce it down to a judgment, and you go after then, and you can garnish wages. You can get court orders to do those things in the civil arena too.
Was it a simple bankruptcy filing that gets you out of this as the perpetrator?
Some of it would be, but the other thing is too. This guy is probably a bit of a deadbeat. And I don't want to discourage Justin from doing what he needs to do to try to get compensated from this guy. Sometimes you're trying to squeeze blood out of a turnip and you're just not going to get much out of it. So let's just say whether he hires a lawyer or not, he goes and he files a lawsuit against the guy for the full value of his damages, which are pretty easy to distill down to numbers, right? You know exactly what the parts cost, whatever he was charged and would have been paid, how much he had to pay to buy a new engine. Let's just call it $22,000. He goes and he brings this guy into court, or the guy doesn't show up, and he's somehow able to get a judgment, though, against this guy, and then he's able to try to garnish the guy's wages, but that presumes the guy has now a job. He's being paid wages, and that the employer then... he's doing everything above board so that the employer is going to be able to then deduct the amount of the garnishment. I mean, look, this is a messy situation, and it doesn't seem to have a lot of great outcomes right now if you're dealing with a deadbeat who's in the jail system or who's in the criminal justice system. I call it the jail system.
So what are your thoughts, though? Like, if it was you, would you just say, well, I'm gonna lose on this one, or would you do that to try to get the $7,000 in the small claims, or go big?
No, I would go, I'd go big. All right.
Okay.
I'd go after the guy. But I'd also recognize at some point it might be, I might end up with a Pyrrhic victory here where I'm not able to actually get the one thing that I really want, which is my money back to pay for all of this. And I don't know if he has insurance, which might cover some of that. I just don't, I don't know all of those details. I'm just throwing some of this out there. But small claims court, yeah, it's a little bit easier. You can do it yourself, and the rules are more, they're designed to expedite things, make it a little less formal.
So maybe you could quickly get that $7,000 you had to get the new motor. Again, might have to blow off that 16.
Oh, okay, let's talk about it. Now you've got a $7,500 judgment. It's the same issue. Does this guy have 75? I mean, maybe he doesn't have 22,000. I mean, he might not have 7,500 either. The question is, does he still have a lot of these parts, and can those then be, the prosecutor seize those in whatever state the guy is in? Can those be sold and used to pay back the victims here? And that may just be done within the criminal context through the restitution system.
Interesting. The thing it should be like that Seinfeld episode. He should have to be Justin's butler.
I haven't seen that.
That's a great one. I think it was Costanza had to be someone's butler for charge. That's justice.
I love that. Now I want to see that.
That is justice. Okay, we got a couple more. I'll tell you what. We'll do the HOA deal. They're trying to. I'm going to call it the case of the tiny shed.
You're listening to the Law Frog Radio Show with David McDivitt and Ross Ford on Kilo 94.3 FM. Presented by McDivitt Law Firm.
You ready for another trip around the sun or what?
Oh, yeah.
Yeah?
I had my birthday, too, toward the end of the year.
Really? When's your birthday?
A week before Christmas, December 17th.
17th. Oh, so you missed the cut. You're not Capricorn, are you?
No, I'm Sagittarius.
Very close. I'm 24th.
Okay.
I'm a Capricorn.
Yeah,
we just barely split.
What do they call the cusp if you're between the two or right there? I don't know. I just know my star sign is magic.
Really? I did not know that. Yeah. I don't even know what mine is. Probably burgers. Burgers or beer.
Magic and burgers and beer.
I think so. Okay, let's get back to it. We were talking restitution in regards to a citizen who was part of that, what did you just call it, scam? Yeah, where a guy was just stealing motors and parts from cars that he was supposed to be fixing. And we talked to restitution. Can the guy get money if he wins a lawsuit? It's tough. I mean, yes, maybe. But there's also that chance you could be left with nothing. Josh checked in about restitution. He was told that he would get no restitution because an insurance settlement was reached. And just wants to know, is that legitimate or not? I assume it was a car accident?
Yeah, I don't know. It could have been for anything. It could be an assault. I mean, if the court orders restitution, the idea there is to try to reimburse you for any of the monetary, the things that you can distill down, the economic damages you might have suffered. I mean, like the
doctor bills,
or
personal
repair your
property,
car, repair your car, or whatever. And but what they do is they reduce the amount by any amount paid by an insurance policy. So if he's being reimbursed that same amount by policy of insurance, then the court's not going to order the restitution in that amount.
For that full amount. Okay, yeah. So let me apply this to our previous story. So let's say our buddy Justin has insurance, and his insurance gives him that $7,000 of the $23,000 to cover his new motor, and then he reaches a settlement for $23,000 against that dude. They would only apply that $16,000 then after that?
Now you're talking about something else. So you're saying that the restitution was awarded? Wait, okay, slow down. He gets the restitution for the $7,000, or he... Yeah,
the restitution, they give him the full $23,000 originally, and then his insurance winds up ponying up $7,000 to cover that motor. They would take that from that $23,000 in restitution?
Yeah. Basically. So in that situation, the insurance isn't going to pay him any... I mean, let's say he's truly made whole by the restitution payment in court.
Okay.
He gets miraculously, it turns out this guy stealing auto parts, but he's got a lot of cash.
He's a rich kid.
He's a rich kid.
He's a
kleptomaniac. He's a car klepto. And then he gets the $23,000, $22,000 from the court ordered restitution, and then he turns around and files an insurance claim for that. He's not going to, the insurance company's not going to pay him anything on the policy, because he's already been, there's a court order issuing the requirement that the person, not just the money's been paid, but there's a court order saying you're going to pay this money from this guy. So the two are designed so that you're not kind of getting a double dip.
Okay. So Josh, if your insurance settlement was more than your restitution, you will get nothing. If there's still a little meat left on the bone, he could get that. Let's say his insurance gave him $5,000, his restitution was $7,000. He could still receive $2,000 in that restitution then?
Yeah.
My math is pretty good. All right. That one actually makes sense. This is the first time I've ever put my head fully around one of these questions, Dave. It's this very amazing moment for me. Let's take
There's just a public. I mean, we always start talking about the legal, like the public policy. Oh, we're still talking about you?
Yeah. I'm just basking for a moment.
Let me ask you something.
Yeah.
Why did you take that button off? You wanted applause?
That's sarcastic. This is more genuine. Hi, I just figured out something legally speaking. Bravo. All right, cool. Josh, that should answer your question. That's actually almost cut and dry. What else you want? Let's save the
tried
super
calling
small
Josh,
shed. Yeah, Josh, if you're listening, man, give us a call. We tried reaching out. Let's get to this one. This should be a quickie. RV. It's from citizen Elizabeth. Purchased and paid for used as is RV on Saturday from a dealer. Noticed issues with the vibrations.
Or no, probably not.
We can. You want to try?
Well, I'd love to. I have questions about this.
Okay. I thought this was going to be cut and dry as well. I tried to make the easy ones.
You keep talking about quickies, but I'm more of a
He goes deep?
Yeah.
All right. McDivitt goes deep.
You're listening to the Law Frog Radio Show with David McDivitt and Ross Ford on Kilo 94.3 FM. Presented by McDivitt Law Firm.
Purchased to pay for a used RV as is on Saturday from a dealer. We noticed issues with vibrations when we test drove. Did not take delivery. They are to fix the problem. We have that in writing. If they don't fix this issue to our standards and our safety, can we get our money back? And I think the stickler is paid for as is. Dun, dun, dun.
Okay.
So let's go to Elizabeth. Morning, Elizabeth. You there?
Good morning.
Cool. Can you hear me? All right. You can hear Dave?
Elizabeth, can you hear me?
Yes, sir.
All
awesome.
right. This is great. Thank you for being on here with us. So Ross asked me to do something here. Ross asked me in response to that question to give you what my legal advice would have been if this hadn't already been dealt with by you. And then you're going to tell us how you resolved it, which is a fool's errand for a lawyer. What I would have done knowing that somebody already has the answer. What really I should do is let you tell me what happened, then I would say that's exactly what I would have done.
That's the safe bet.
I won't do that.
You're going to do it?
No, that makes for bad radio.
Okay,
so
yeah.
this
is fun.
So the situation, as I understood it, Elizabeth, and that's why I wanted to talk to you too, is there's a fundamental question here. You've got this RV, you've entered into this agreement, you're going to buy it as is, but they need to make some repairs to it before you want to take delivery of the RV. My question would have been, if you hadn't answered, had you already paid them the money for the RV? Do they have in their hand both the money and the RV that you want fixed? Because the question was, can we basically void the contract if it's not to our satisfaction? And while I think that the legal answer is yes, you sure can. The Uniform Commercial Code that Colorado has adopted governs things like this for the most part, and you have a right to be able to rescind something if they don't honor the contract, and they've already agreed as part of the contract that there's this implied warranty that they will fix it. And then if they fail to do that, you've got avenues to get around it. But if they've got your money, it just makes your life that much harder.
So did they have the money yet when you had the problem with the RV?
Yes. Yeah, we'd already given them a certified check. Yes.
Oh, certified check too. Ouch.
All right.
Okay.
So, but anyway, now.
And you had possession of the RV at that point though, right?
Well, we owned it per se, but we left it with them to get the issue repaired.
See, that's the thing. They had
their RV and they had their money.
Yeah, the RV and the money.
Yeah.
This is getting greasy.
And an obligation to then repair it to your standards. And the question would then be what's reasonable, what would be safe, what a third party would do. All of these things would come into play if you did what you could do, which is if they don't give you your money back or the RV, file a lawsuit.
You gotta go through advance.
Like you didn't have to do that. Is that right, Elizabeth?
Right. We didn't have to do that. They did. They did get it corrected.
This is good news. I'm sorry for you that you had that needless anxiety about it, but it sounds like it worked out. What kind of RV is this? An RV where you can? Is it a fifth wheel or is it one that you drive it itself? Or
it's a 40-foot coach that you drive.
Nice. What year?
2006.
A real land yacht.
I got old 93. It's a little beat up, but it's still fun to get around.
40 foot or two?
Yeah, about 30 some feet.
Wow.
Yeah, it's fun. It's fun.
Do you like it? Have you, Elizabeth, been able to drive it yet or not?
Well, we haven't taken possession of it because they still have to fix the windshield. That was part of the agreement also, that the windshield had to be repaired.
Okay, well,
so we're waiting for the windshield to come in.
Okay, well, it sounds like they're doing the right thing. They're doing right by you guys.
Yeah.
Which is great.
All it took for you was just to ask them to honor the deal and get it fixed. They were cool?
Yeah, they seem to be. It was just a concern of ours. We'd already given them the money. We were already kind of on the hook for as-is, and we're like, oh, shit.
Yeah.
Excuse my language.
I feel naked in the wind here. Maybe if I talk over that, nobody heard that.
I would have gone home, worked out, went back at night, and burned the building to the ground.
There's a song about that.
I know.
Well, Elizabeth, it sounds like you're dealing with a more scrupulous repair/auto dealer than the other guy we were dealing with today.
Right.
Stuff. The guy took all of his stuff. He took his car, took his engine, took his parts.
Or unless it's the same guy and he's currently stripping her RV down to nothing.
Make sure you put eyes on that thing this week.
Yeah. Well, my husband's been checking on it and following up to make sure that they're doing what they're supposed to be doing.
Good.
Like I said, we're just waiting for the windshield to be replaced and then we'll pick it up. But we only trust drove it. We haven't had it in our possession as of yet.
Gosh, that's exciting. I'm so excited for you guys. I've always wanted to have. To go on a trip or be in one of those. I mean, it's just so neat. Well, I have fun with it.
Yeah, that's what we plan on doing. We plan on taking it four-wheeling.
Cool.
Towing our Jeep and going four-wheeling with our Jeep. So
am I talking to myself? Hello? Am I talking to myself here?
What do you...
I drag my Jeep around in the RV and go get in the woods.
That's what you do?
Yeah.
There you go.
Yeah, watch out for that guy, that really funny-looking guy in the woods that you see. That's... It's probably not it's just Ross Ford, but
Hey, how's it
the guy
going?
that wants to burn buildings.
You want to be my RV buddy?
Hey. Let me see your Jeep.
That's awesome. All right, well, hey, if they give you more guff, let us know. I can always go home, work out, come back, and burn the building to the ground. All right?
I'll keep that in mind, Ross. I got your number.
All right, you got the number right here.
Take care.
That's awesome. That's cool. There's still some good businesses out there. We hear it every once in a while.
Oh, most of them are.
Few and far between, but I would say mostly, right? That's a good point.
But the thing is, when you work in the kind of field I do, you're trying to help people when they've been injured, when they've been hurt, and then collaterally, I do the Law Frog stuff, so I get exposed to a lot of other things, and with my legal background, I mean, you're kind of in the world then of things that don't go right.
Right.
But most of the world goes right. Well, most things tend to go right. Anyway, I'm going to stop because there are things in the world that are not going right.
Yeah.
Very significant things.
It's kind of feast and famine there, Dave.
Yeah.
Oh, okay, we'll get to the case of the tiny shed. That'll be our closer here today. Any questions you want, you can call us on the rock lines at 633-KILO. We'll get you on the air here this morning. Let's get to this one. Interesting. And one of these things I think is kind of cut and dry, but then you go into a long tirade about it, and I'm wrong.
Wait, are you saying that I go into tirades?
Sometimes.
Are you calling me my dad? Are you calling me Mike McDivitt here?
I've rented the same apartment going on 2 years, but the owner hired a property management company about a year in. I refused to sign their lease, so the owner let me stay month-to-month basis under the original lease agreement. Management company is now trying to charge me daily late fees for the first time. Am I legally required to pay these? And can I sue them for causing me so much stress? I am sick. What do you think about that?
There's a lot to unpack there. This is going to be one of those where I'm going to give an answer. I'm not even 100% sure, just because I'd like to know a few more things here. So it sounds like before the management company was hired, she had an agreement with the owner, the landlord, to go out of a written contract, and then they basically go month to month.
Which is fairly normal if you've never rented before.
Yeah, and for the most part, a lot of the terms of the existing lease, since you already had a lease, are going to kind of dictate the general parameters of what life is like under that month-to-month contract.
And usually they'll charge you a little bit more because it's month-to-month, and you can walk away after a few weeks' notice.
Yeah, and they can evict you, and they can say, okay, I'm not going to renew this month-to-month anymore, and they have the right to. You both have the right to just walk away at, reasonable notice within that 30-day window, and it could be that you got to give 30 days notice, so you've got one more month under your belt. And so then they bring in the property management company, and I don't understand what that management company has done. Did they inherit the existing lease because she wouldn't sign their lease? Did they have an agreement then, the property management company, with the landlord, that they would allow and they would just facilitate management of this property pursuant to the terms of their month to month? And what late fees are they charging her? Are these based on their contracted terms that she didn't sign up for? Is it just because is she not actually paying her month-to-month rents? It's June 7th and she has to pay for May and she hasn't paid it yet. And so they're going to levy late charges on that. I'm really struggling with this one. So,
or maybe added fees from the new management company in regards to property maintenance, stuff like that. So let's say it's that. Let's say it's property maintenance fees that they've added to the contracts for all those who signed that lease.
Yeah, but she didn't sign that
lease. And she has a month-to-month lease signed from the actual owner, which supersedes what?
Well, I don't know that that's the thing, and that's where I would, they're probably, if I say they're probably, there may be landlord, tenant lawyers listening right now who are just, they're pulling their hair out that I'm not nailing the answer. There's probably some obvious answer here, but I just don't know if she's still under the lease from the landlord, or the fact that you hired the property management company kind of supersedes any prior lease. I mean, I don't know. I mean, the landlord brought this company in to help manage this property. And by the way, I'm now getting stressed.
Can we sue them?
Yeah.
I'm stressed too then.
I agree. We want to sue them for this. And that's a separate issue here, whether or not you can actually sue for what they would call negligent infliction of emotional distress. Are there other things that are manifesting themselves? I mean, what sickness is this?
Because some people have won settlements against, telemarketers and stuff, or bill collectors that, they call and harass them for payments and stuff. That has been a thing. I don't know if it falls under management companies.
I just don't know if this falls under that too. I don't know what the situation is. Listen.
Well, I guess the first step is to get a hold of the original owner, right? I
think she needs real clarity with that.
And I would assume, though, with if she actually has a signed month-to-month lease from the original guy, that would outduel an unsigned contract with the new management company.
But if she's got a month-to-month lease, the property management company then theoretically would have the right to evict her and terminate it if the landlord in fact had turned this over to them. It is just so bizarre. Like, I can't wrap, and my mind doesn't wrap around a lot of stuff. I understand that. It's certainly not wrapping around this.
Well, you can always go for the old go home, work out, come back later, and burn the management company's house down.
Just make sure it's not your own.
Again, there are no easy answers.
Well, this one, I feel I'm punting on this because I don't quite know how this worked out. Like, I don't understand the Lego pieces here.
All right, we'll see. We didn't answer the last time, so we'll give her one more chance to see if we can ask her if she has a signed contract here.
You're listening to the Law Frog Radio Show with David McDivitt and Ross Ford on Kilo 94.3 FM. Presented by McDivitt Law Firm.
Who's the responsible one? Your dad or your mom?
My mom.
You didn't even stutter.
She has a PhD in school psychology. That's her background. Like, she's the, I don't want to say the brains because I'm brainy too, and I'm kidding. She's the brains. No, she's fantastic. She is the driving force. She and my dad and my sister, and then I'm there. I'm along for the ride.
It's the whole family. So
and I'm drinking coffee, by the way. Which, by the way, we haven't talked about this. Do you drink coffee?
Yes, I do. I chug-a-lug it.
I started in October 2022. I'm hooked. I love it.
You hadn't drunk coffee before then?
No, 44 years old. I waited until right before my 44th birthday to drink coffee.
That is so bizarre. Usually at that age, I've noticed with people in coffee who haven't partaken, and also people who haven't really tried beer that late in life, they just can't find a taste for it. What got you in? My mom kept sending me articles about the health benefits of coffee. I mean, this is black. It's straight. It doesn't have any cream or sugar in it. So I'll do some cream on the weekend. My wife mixes up a little bit of a latte, but I'm a black coffee guy, a couple gallons. Kahlua on the weekend. I've heard that's a good mix. Let's try it. We can do it right now if you want. Oh, yeah, it's 5 o'clock 15 minutes somewhere. The show here. That's such a cliche, but it's true. It really is 5 o'clock somewhere. And they are drinking Kahlua coffee. And a lawyer, man, you got some long nights, long days, and you're not even dependent on caffeine. That's amazing. I just naturally, thank you. Welcome to the crutch. Let's see. Let's get to our last couple of questions here. We'll get to the case of the super short shed. To wrap it up, we go to Logger Mike, though, on line one with an interesting one. You want to gift your guns to your neighbor if you pass away. Is that right, Mike? True. How does he go about that, Dave? Hey, Mike, this isn't something I've done a lot of, so I'll just tell you, there are lawyers who specialize in firearm transfers. I do know there's some things you need to be careful of that may mean that it's not allowable, although it may very well be allowable.
And one thing that I'm aware that people do sometimes is they create a firearms trust that allows for these firearms to be, because you want to make sure that when you die, your firearms go to a close friend. Is that right?
Correct.
Okay. Let's presume for a moment, because you don't need to get into the details, but has your friend ever passed a background check? Do they own firearms already, or would they pass a background check?
He would pass a background check. He already has some guns.
Yeah,
but
yeah, I suspected that was the case.
So no pre-existing reasons he can't have a firearm.
Yeah.
Correct.
Yeah, and that's a predicate to being able to make this happen anyway. But I think if you speak to somebody, I would plan on doing that now rather than just assume that you can just will it to them. It just makes it cleaner, so that somehow if there's an executor of your will, they aren't surrendering the firearms to the state, if that's what you want to avoid, or somehow going to a family member that really wouldn't be the responsible person to have it. Plus, more than that, you actually specifically want this person to have them. So do what you need to do to make that clear. And somebody I think who does estate planning may have a lot of familiarity with that already. And I would recommend you reach out to an attorney who does estate planning, and they ought to be able to help you craft something to just make sure that this is done properly.
Especially with the expensive firearms.
Yeah, and then there are state laws, there are federal laws that will affect this, and also has to do with the kind of firearm we're talking about, too. I mean, so there are laws that go along with all of this.
Yeah, it's just a 45 and a 9mm.
Okay, well, those are pretty basic. So we're not talking about an old musket or a...
One thing we read when we were in the commercials there was the fact that, just don't get caught napping. Make sure you have some kind of documentation as to what your will is, because if it falls into someone else working your estate, they do whatever they want.
Yeah, and I think that's the case. We're talking about firearms or anything. I mean, just, take a few steps here to try to protect the people you care about most when you die. So that the things that you might want somebody to get when you die, whether it is your favorite sofa or a 45, you get where they need to go.
Yeah. All right, Mike. Good luck, all right?
Thank you.
There you go. All right, let's get to this one. It's an interesting one. Because it's more like a wrong numbers placement, I think. So it comes to us from
you're talking about your numbers again. You and your wrong numbers.
Todd, his question, it's a long list here. Live in an HOA, has an agricultural review committee that approves or denies home improvements on the property. I'm building a storage shed in my backyard. Great idea, by the way. It's a good way to clean out the garage. So it has a footprint of 160 square feet, and the roof height is almost 17 feet, 16 feet, 8 inches. According to the design guidelines, here's what they say on the HOA site. Property investments improvements. Accessory structures. The following standards shall apply to all structures. Max square footage of accessory structures, gardens, sheds, greenhouses shall be 240 square feet, or I assume less. It doesn't say less here. So he meets that requirement because he brings in 160. Max height of a garden shed, playhouse shall be 8 feet. And gazebos limited to 12 feet. An 8-foot shed is not much of a shed. And then it says it has to be similar to the residence, which is usually a normal thing.
Right, the way they look. They have to look kind of like the house, the color, the shingles, that type of thing.
So B, it states the max height of garden sheds. They're saying that a garden shed in their eyes is all sheds. I don't garden. This is a storage shed to store our tools, sporting equipment, camping stuff, and more. So, is it legal for the HOA board to interrupt the design guidelines the way we want to?
And I think interpret.
What do you mean?
You read the word as interrupt, which it says in there, but I think it's interpret.
Oh, okay. Design. Okay. So they interpret the design guidelines the way they want to. They have yet to approve a meeting with me. I've requested mediation and hearings to discuss this. So what does he do? 8 foot.
I think so. I think a couple of things here. Without getting into the factual issues, it could be that the guidelines are a little ambiguous unintentionally. That when they crafted the covenants and the HOA guidelines, when they said garden shed, that presumably meant any kind of exterior shed for purposes of non-living or non-habitable shed. It doesn't have plumbing. It's for storing rakes, potting soil. Well, that you store that in a storage shed too. So maybe it's an issue of semantics. This is a really prime example of a situation where you've got two parties here. You've got the homeowner who wants to do the right thing, but thinks that these rules shouldn't actually prohibit it from doing it. You've got the Architectural Review Board, a.k.a. the HOA board. It's the same group of people, and exercising what ostensibly is their right to communicate with this, and they presumably, or it sounds like they're presumptively rejecting what he's trying to do here. If he can't square this away with them, one thing he can do is file a motion for declaratory judgment in civil court, which is, it's not a lawsuit in the traditional sense, which is you did something wrong and I'm wronged by what you did. It's kind of a presumptive thing that you do to make sure that you don't get to that point where somebody isn't suing the other person saying you violated this. They have a real question of the way to interpret those HOA guidelines. He says he should be allowed to do it at 16. They said you're capped at 8. If he wants to do it, one thing he could do is get in front of a judge and have the judge interpret these HOA guidelines, and that both sides get clarity and say, yeah, this guy can do it. Because what he doesn't want to do is build it at 16, only to find that the HOA then is able to bring him into court. They get a successful judgment against him saying he has capped at 8, and then he has to go through the time and the expense of retrofitting his 16-foot shed down to 8 feet. Because that will happen.
And that is the worst case scenario.
That's a worst case scenario. Well, yeah, worst case would be that somehow they tell him that the shed is entirely impermissible for one reason or other, and then he has to scrape the whole thing. I doubt that would happen. I think he's going to be okay at least at 8 feet. So you've got a real issue here, and the law has now. Again, sometimes I'm really pragmatic in the way that I interpret issues, and sometimes I get really kind of granular on what the legal issue. This is a prime example of where you can use this tool in the law called a declaratory judgment to get a judge to declare that this is what is meant by this thing, and so that the judge isn't going to say, yeah, you can go and do it. The judge might just say it might be limited to that the HOA contract, when they say garage shed, garden shed means all exterior shed-based applications. So that way everybody they're on the same page, which sometimes what you want to do. It's like when you're, so a coach, they're going to go down to the field and they want to make sure that they have an eligible lineman, for example. Sometimes they get called an ineligible lineman downfield, but they want that person to be an eligible receiver. They go up and they tell the line judge right away, hey, so-and-so, 72 is eligible. Right?
Same type deal.
Right. Same kind of thing where you're just getting the judge to come in and say, okay, this is what the rule is going to be for this play right here.
Huh. And now, not to defend the HOA, because I'm not really a believer in that, but if they buttoned up their stuff and said this applies to all outbuildings, that would cover their ass a little bit better, probably?
They're saying, based on the way this was written, there's clear ambiguity, I think, in the nature of the guidelines, but that doesn't mean that they're going to lose because of that ambiguity. That could be resolved. Because here's what's going to happen. He's going to build a 16-foot shed. They're going to sue him if he doesn't take it down. Then the ambiguity is going to get resolved at a much greater cost to the homeowner, unfortunately.
Probably so. Wow. Or just build more square feet. You almost add another 100 square feet to your design to just build a bigger, lower shed.
Yeah.
I mean, I know 8 feet isn't exactly great, but if you add another 100, or do this, build 12 sheds all over your property.
Thank you for listening to the Law Frog Radio Show with David McDivitt and Ross Ford on Kilo 94.3 FM, presented by McDivitt Law Firm.